Chapter 20. Husband and Wife Fraudulent Marriage Settlements. SS 298. The Marriage Relationship. It would be impracticable to devote separate chapters to the consideration of the different frauds upon creditors incident to each of the various relationships recognized by law. But, as the fairness and good faith of transactions and conveyances between husband and wife are so frequently challenged and assailed by creditors, the rules and decisions governing this branch of our subject must be discussed. As will appear, husband and wife have been made by legislation independent legal personages. A debtor, when threatened with insolvency, naturally reposes confidence in his wife. The relationship inspires this confidence, and it very often results that she becomes wrongfully possessed of the creditor's trust fund. The statutes conferring upon married women the power to hold and convey property much the same as though they were single, have unfortunately encouraged husbands to confine to the keeping of their wives' property which should have been turned over to creditors. Frauds committed by the husband and wife upon one another, or in contemplation of, or after entering into, the relationship, will also call for incidental discussion as we proceed. SS 299. Wife is husband's creditor. A wife can become a creditor of her husband, and he may pay an honest debt to her. Though as to other creditors the claim may appear stale and ancient, the debtor is not compelled by law to resort to the statute of limitations as a defense. Nor can others interfere or insist upon it for him. Nor is the wife estopped to receive payment of a debt of this character. The rule as it prevailed at common law was that a husband could not contract with his wife, her money not held to her separate use, coming into his possession, was regarded as his property, and his promise to repay such money to her could not be enforced either at law or in equity. This rule, as we have said, has now been almost universally abrogated. In many respects a wife may, under the existing policy of the law, deal with her husband, as regards her separate estate, upon the same terms as though the relationship had no existence. Thus in a recent case in Massachusetts, in which the opinion was rendered by Chief Justice Gray, now one of the justices of the Supreme Court of the United States, it was decided that where a wife loaned to her husband, upon a promise of repayment, money constituting a part of her separate estate, a conveyance of land made by him to her, through a third person, in repayment of such loan, and free from a fraudulent design, would be valid against his creditors. Manifestly a wife's relinquishment of her dower right is a sufficient consideration for a reasonable settlement upon her out of the husband's property. SS 300. Transactions between how regarded. Transactions between husband and wife, to the prejudice of the husband's creditors, are, however, to be scanned closely, and their bona fides must be clearly established. Lord Hardwicke said, "I have always a great compassion for wife and children, yet, on the other side, it is possible, if creditors should not of their debts, their wives and children may be reduced to want." The court observed in Hoxie v. Price, on account of the great facilities which the marriage relation affords for the commission of fraud, these transactions between husband and wife should be closely examined and scrutinized, to see that they are fair and honest, and not mere contrivances resorted to for the purpose of placing the husband's property beyond the reach of his creditors. In all such cases the parties are under temptation to do themselves more than justice. What is secured to the one is apt to be shared by the other. When a creditor challenges such a contract for fraud, slight evidence will change the onus and cast on the conjugal pair the duty of manifesting the genuineness and good faith of the transaction by such evidence as will satisfy or ought to satisfy an honest jury. There is, however, no absolute legal presumption that a conveyance of land made by a debtor to his wife is fraudulent as against a creditor of the husband whose judgment was recovered after the conveyance. A wife may be held as trustee ex maleficio for the benefit of her husband's creditors. SS 301. Burden of proof. It is said by Mr. Justice Taylor in the case of Horton v. Dewey that, in a contest between the creditors of a husband and the wife, if the wife claims ownership of the property by a purchase, the burden of proof is upon her to prove, by clear and satisfactory evidence, such purchase, and that the purchase was for a valuable consideration paid by her out of her separate estate, or by some other person for her. And it is further observed, in the course of the opinion, that in all such cases the burden of proof showing the bona fides of the purchase is upon her, and she must show by clear and satisfactory evidence that the purchase was made in good faith, with her separate estate, or for a consideration moving from some person other than her husband. In all such cases the presumptions are in favor of the creditors, and not in favor of the title of the wife. The mere recital of a valuable consideration in the instrument or bill of sale has been considered insufficient to support a verdict in favor of the wife. Such a recital is regarded as evidence only between the parties and their privies. It must be remembered that the presumption of possession of the wife's property by the husband, and that he is therefore prima facie the owner, has been impaired by modern innovations in the law, since under the present rule the wife may generally take by gift from her husband as well as from others, and by purchase from anyone. Her separate and personal possession of specific articles must draw after it the presumption of ownership, and there is no longer any reason for making her case exceptional or excluding her from the operation of the general rule. SS 302. Mutuality of fraudulent design. To render an ante-nuptial settlement fraudulent and voidable as to creditors, it is, as we have seen, necessary that both parties should concur in or have cognizance of the intended fraud. If the settler alone intended a fraud, and the prospective wife had no notice of it, she cannot be affected by it. Marriage, as already shown, is a consideration of the highest value, which, from motives of the soundest policy, is upheld with a steady resolution. Fraud may be imputed to the parties either by direct cooperation in the original design at the time of its concoction, or by constructive cooperation in carrying the design into execution after notice of it. The question of intent must, as in other cases, be submitted to the jury. Husband as agent for wife. It is settled beyond controversy that a husband may manage the separate property of his wife without necessarily subjecting it, or the profits arising from his management, to the claims of his creditors, the wife being vested with the right to hold and acquire property free from the control of her husband. The legitimate inference seems to result that she can employ whomsoever she desires as an agent to manage it. To deny her the right to select her husband for that purpose would constitute a very inequitable limitation upon her right of ownership, compelling her to resort to strangers for advice and assistance, and would perhaps seriously mar the harmony of the marriage relation. In Tresh v. Wirtz, the vice-chancellor said, "A man's creditors cannot compel him to work for them. A debtor is not the slave of his creditors. The marital relation does not disqualify a husband from becoming the agent of his wife. All the property of a married woman is now her separate estate. She holds it as a feme sole, and has a right to embark it in business. She may lawfully engage in any kind of trade or barter. If she engages in business, and actually furnishes the capital, so that the business is in fact and truth hers, she has a right to ask the aid of her husband, and he may give her his labor and skill without rendering her property liable to seizure for his debts." In Merchant v. Bunnell, Davies, Ch.J., said, "This court has frequently held that there is nothing in the marriage relation which forbids the wife to employ her husband as her agent in the management of her estate and property, and that such employment does not subject her property or the profits arising from such business to the claims of the creditors of her husband." SS 304. Wife's separate property. It follows from the cases cited that a creditor cannot subject to the payment of his claim lands belonging to the debtor's wife, the purchase money of which constituted a part of her separate estate, and where the wife was the owner of a farm upon which she resided, and which the husband carried on in her name, without any agreement as to compensation. It was held that neither the products of the farm, nor property taken in exchange therefor, could be attached by creditors of the husband. SS 305. Mingling property of husband and wife. If a wife permits her husband to take title to her lands, and to hold himself out to the world as the owner of them, and to contract debts upon the credit of such ownership, she cannot afterward, by taking title to herself, withdraw them from the reach of his creditors, and thus defeat their claims. At least the courts of New Jersey so hold. And where a husband and wife acquire property by their joint industry and management, the title being taken and held in the husband's name, a conveyance of the property to the wife, without consideration, to the prejudice of existing creditors of the husband, will not, it seems, be supported. It is said by the Supreme Court of the United States, if the money which a married woman might have had secured to her own use is allowed to go into the business of her husband, and be mixed with his property, and is applied to the purchase of real estate for his advantage, or for the purpose of giving him credit in his business, and is thus used for a series of years, there being no specific agreement when the same is purchased that such real estate shall be the property of the wife, the same becomes the property of the husband for the purpose of paying his debts. He cannot retain it until bankruptcy occurs, and then convey it to his wife. Such conveyance is in fraud of the just claims of the creditors of the husband. Humes v. Scruggs is discussed and analyzed by Choate, J. in Van Cleek v. Miller, and it was very properly considered that the language was not to be deemed as asserting the doctrine that the wife whose monies were so received by the husband ceased to be his creditor for the money so retained, or forfeited by the use which she had allowed the husband to make of the money any of her rights as creditor in case of bankruptcy, if the money is received by the husband as his wife's, and to be accounted for or secured by him to her, he waiving his marital rights thereto, she has an equitable right to the funds sufficient to sustain a mortgage subsequently given to secure it. And the mere lapse of time would not invalidate the security. SS 306, Marriage Settlements. Amount of settlement, if the amount of property settled is extravagant, or grossly out of proportion to the station and circumstances of the husband. This has been regarded as of itself sufficient notice of fraud, in an able opinion. In the case of Davidson v. Graves, Justice Knott says, there is no case that I have seen where a man has been permitted to make an intended wife a mere stock to graft his property upon, in order to place it above the reach of his creditors. A marriage settlement must be construed like every other instrument. The question may always be raised whether it was made with good faith or intended as an instrument of fraud. The usual test is that the settlement must be reasonable considering the grantor's circumstances. If it complies with this requirement, it will be upheld. When a person possesses a large estate and, owing debts inconsiderable in amount, makes a voluntary settlement of a part of his property upon a wife and child, retaining enough of his property himself to pay his existing debts many times over, it would not be a fair or reasonable inference that such a transaction was intended to hinder or defraud persons to whom he happened to owe trifling debts. A settlement upon a wife of all a man's property exempt from execution cannot, of course, be upheld unless the marriage was not only the sole consideration for it, but the agreement was entered into by the wife in ignorance of her husband's indebtedness, and without knowledge of circumstances sufficient to put her upon inquiry. In Columbine v. Penhall, a celebrated English case, the court said, where there is evidence of an intent to defeat and delay creditors, and to make the celebration of a marriage a part of a scheme to protect property against the rights of creditors, the consideration of marriage cannot support such a settlement. Where there is evidence of an intent to defeat and delay creditors, and to make the celebration of a marriage a part of a scheme to protect property against the rights of creditors, the consideration of marriage cannot support such a settlement. SS 307, Post-Nuptial Settlements. The court decided in French v. Holmes that a voluntary gift by a husband to his wife, if he was indebted at the time, was prima facie fraudulent as to creditors. Davis, J. states the rule to be that a voluntary post-nuptial settlement will be upheld if it be reasonable, not disproportionate to the husband's means, taking into view his debts and situation, and clear of any intent, actual or constructive, to defraud creditors. Mr. Justice Field observes, a husband may settle a portion of his property upon his wife, if he does not thereby impair the claims of existing creditors, and the settlement is not intended as a cover to future schemes for fraud. A settlement consummated after marriage, in pursuance of an agreement entered into before marriage, will be upheld against creditors, and a voluntary conveyance for the benefit of a wife and children will not be overturned at the suit of a mortgage creditor who by reason of his own lashes has lost his ample security. SS 308. Purchase after marriage. Purchases of either real or personal property made by the wife of an insolvent debtor during coverture are justly regarded with suspicion, unless it clearly appears that the consideration was paid out of her separate estate. The community of interest between husband and wife requires that purchases of this character, which are so often made a cover for a debtor's assets, and so frequently resorted to for the purpose of withdrawing his property from the reach of his creditors and preserving it for his own use, should be closely scrutinized. And in a contest between the creditors of the husband and those of the wife, there is, and should be, a presumption against her which she must overcome by affirmative proof. This was the rule of the common law. And it continues, those statutes have modified the doctrine which gave the husband title to the wife's personalty. SS 309. Valid gifts, subsequent insolvency. It is said in a recent case in Texas that a gift from the husband to the wife is not necessarily fraudulent and void as to existing creditors. It might be a badge of fraud, a circumstance to be considered in determining whether the intent was fraudulent, if it were shown that he was then heavily in debt. But it does not follow that, because a man may be indebted to an inconsiderable or even a considerable amount at the time, he cannot settle a part of his property upon his wife or children, provided, as we have seen, he retains an ample amount of property to liquidate his just debts. nor will the settlement be affected because it may turn out afterward, from accident or ill fortune, that his property has perished or been swept away. The general rule then is that a conveyance by a husband, solvent at the time, to his wife and children, will be supported if he retains ample means to pay his debts, and the gift or conveyance is a reasonable one. SS 310. Articles of separation, where a husband and wife executed articles of separation by which the husband bound himself to pay, in trust for his wife, a certain amount of capital and interest on it till paid. It becomes a voluntary settlement if the parties become reconciled and again cohabit, even though there be an agreement that the settlement shall stand. A settlement has been avoided upon this theory, where it appeared that the amount of the husband's estate was $16,132, while the settlement was $7,000, leaving $9,132 to meet debts confessedly due, amounting to $9,306. SS 311. Statute of Frauds. In New York, every agreement or undertaking made upon consideration of marriage, unless reduced to writing and subscribed by the parties, is void, and a settlement made subsequently, in pursuance of such void agreement, is invalid as against creditors. SS 312. Insurance policies. As we have shown, in New York, policies of insurance may be placed upon a husband's life for the benefit of his wife, free from the claims of creditors, but where assignments of policies, taken out by a debtor who is insolvent, are made in trust for the benefit of his wife, such transfers may be annulled in favor of creditors. The court, however, say in the case last cited, that they do not mean to extend it to policies effected without fraud directly and on their face for the benefit of the wife, and payable to her. Such policies are not fraudulent as to creditors. In cases where a debtor at his own expense effects insurance on his life as security to a creditor, the representative of the debtor gets title to the surplus after the debt is paid, and if the debtor in his lifetime pays the debt, he is entitled to have the policy delivered up to him, as already shown. A man may devote a portion of his earnings to insurance for the benefit of his family. SS 313. Competency of wife as witness. On a creditor's bill to set aside a conveyance of land by a husband to his wife, she is regarded in Illinois as a competent witness to prove the consideration of the conveyance and its good faith. It seems, however, to be doubted whether a wife can be compelled to testify against her husband when he is a co-defendant with her, if the husband objects to her examination. While the Act of Congress cut up by the roots all objections in federal courts to the competency of a witness on account of interest, it is considered that the statute has no application to a wife, as her testimony is excluded solely upon considerations of public policy and not of interest. SS 314. Fraudulent conveyances in contemplation of marriage. Alienations of real property by a man about to be married, made without the knowledge of his intended bride, and with the intent and object of depriving her of the rights which she would otherwise acquire in his property by the marriage, may, as we have already seen, be avoided by the wife as fraudulent. In Smith v. Smith, the Chancellor said, "I am of opinion that a voluntary conveyance by a man, on the eve of marriage, unknown to the intended wife, and made for the purpose of defeating the interest which she would acquire in his estate by the marriage, is fraudulent as against her." The doctrine is not limited to covenant conveyances of realty, but where personal property is disposed of by a colorable transfer, the husband retaining a secret interest, and the ultimate object being to deprive the wife of her share of it, the conveyance may be avoided. The rule is also applied and enforced where the conveyance is made by the husband during coverture with a like intent and purpose. Thus in Gilson v. Hutchinson it appeared that a mortgagor procured a sale of the mortgaged estate under a power contained in the mortgage, with a view to evade liabilities to his wife, from whom he had been separated, and to deprive her of her right of dower. The court held that she could maintain a bill in equity for the recovery of the property, both as administratrix and in her own right. The rule has been said to embrace conveyances made by the intended wife as well as by the husband. Brickell, C.J., said, "We confess an inability to distinguish the ante-nuptial frau of the husband from the ante-nuptial frauds of the wife, or to perceive any sound reason for repudiating and avoiding the one, while permitting the other to work out its injustice and injury." SS 315. Fraudulent transfers as affecting dower. It seems to be quite clearly established that where a deed made by a husband and wife is set aside as a fraud upon creditors, the judgment will not operate to bar the wife's right of dower. The creditors cannot claim under the conveyance and against it, or ask to have it annulled as to creditors and held valid as against the wife. The theory of the law is that the wife cannot release her dower in her husband's real estate, except by joining with him in a conveyance. A release to a stranger to the title is ineffectual. And as the husband's deed is declared void at the creditor's instigation, the wife's release falls with it. Dower is not barred by an assignment under the Bankrupt Act.